To ensure justice is made, I will make 5 brief statements and then state my name.
No,
Dana
you will
from the
state
forensic
your
center.
name.
One for
No,
the
no. Whoa, 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 whoa.
I did nothing.
Whoa.
I did nothing.
Right here. Say right here.
I did nothing. What did I do?
Say right here.
I left 2 notes. One for
No,
the
no, face me.
For the record, Mr. Enright remains incompetent, but I guess that.
Yeah, I know. The magistrate may abuse their discretion. So the motion for that modification is denied.
I'm sorry, I didn't hear you.
Denied.
Oh, I'm still waiting for the hearing for the jurisdiction hearing. Put in the
For what?
jurisdiction hearing. Put in a motion for a dismissal for lack of jurisdiction.
Denied. Court calls the case of the People versus Thomas Chang.
Your Honor, Joe Simon on behalf of Mr. Chang, making his way to the podium. State your name, Thomas.
Thomas Chang.
Thank you.
Your Honor, first things first, the court has my substitution.
That was a question.
Yes.
I did. Yes.
Thank you, Your Honor. And secondly, the request that I'm going to make is contingent on, we want to address bond. That's okay?
Sure.
Your Honor, I told Ms. Grosso I'm requesting only a 10% privilege. I'm not going to request a bond reduction at this time. My client's 22 years of age, has no prior criminal history. His bond is currently set as $200,000 cash or surety. I understand I wasn't at the arraignment, but the safety of the victim was an expressed concern by the people, as well as his possible risk of flight. I can tell Your Honor that my client is a United States citizen. There's some information that his family resides in Saudi Arabia, and that is his permanent address. Well, that is true, and it's also not true at the same time. But he's a United States citizen who has a residence here. That is his full-time residence. Your Honor, I'm only asking for a 10% privilege because the bond could have been posted. The problem with the surety bond, as the court knows, is that the family or others who post it lose that money permanently. And if it were to be a 10% privilege, the family, assuming someone complies with their conditions, will get it back, less 10% for administration. And that is our request. Now, my client's family is here. They came from Saudi Arabia. His parents are here today in the front row, as well as his uncle who lives locally. The complainant and my client do not live together. They do not attend the same university. As I understand, she's a student at the Eastern Michigan University. My client's University of Michigan student. They do not reside together. They have no reason to have contact. And my client would abide by that. So in other words, Your Honor, my request isn't yet this time to try to lower the bond, but simply to the court allow to a 10% privilege. Again, the surety.
But the surety, I mean, if we're really, just to be blunt about it, if we're really talking dollar amount, I understand what you're indicating to the court. But if it's a 10%, who's pledging the additional amount?
Well, there wouldn't be an additional if it's 10%. Are you asking
210%? Somebody is not pledging it, but somebody's going to promise to pay the 200,000.
Oh yeah, that'd be my client's parents. I'm sorry, misunderstood your court's question. And you're right, Your Honor. There's just 2 differences on a surety. Surety is the number one difference is the court would be holding $200,000 for the pendency of the case. At the end of the case, it would be returning $200,000, but the person who paid the surety would be out $20,000 permanently. In this case, my client's parents would post a $20,000 if the court permitted a 10% privilege, and they would be responsible.
I mean, I understand the argument, Mr. Simon, but I mean, again, to the extent a dollar figure to secure the defendant's presence is necessary, it almost seems to me that one might get to a 2 million, 10%.
Oh, Your Honor, my client has ties here. He's retained client counsel.
I'm just saying, I'm just talking in terms of the argument
Esoterically?
regarding the amount.
Oh,
That's all I'm saying. If to the extent that the $200,000 is the amount that needs to be secured.
Yeah, and frankly, I think that's a very high bond, but I don't think it would ever be higher. And here's why. Here's why. My client's guidelines on his worst scoring, if we go best to worst, are a straddle cell. He can be secured here by turning a passport over, but his also to indicate his mother is going to stay here during the pendency of the case, and his father's trying to relocate his job back to an office here in the state of Michigan. They're invested in terms of his flight risk. There are ways to ensure he won't be a flight risk. There are also other ways to ensure safety that he's willing to abide by any condition that I've seen the court impose before in cases like this.
Response.
Your Honor, the reason that we asked for 250,000 in this case was because the defendant and the victim have been dating for 2 years. They were together on the date in question in the living room having an argument because the defendant accused the victim of cheating. He got on top of her, held her down with both of his hands, releasing his left hand and grabbing her by the neck, strangling her, causing her to struggle to breathe to the extent that she felt dizzy. He was able to speak, but the defendant cut her off and said, "It's your fault." He then got off of her. They separated for a moment, but he asked her to go to the bathroom to smoke some weed. She agreed, went into the bathroom, strangled her again. At that point, he cornered her in the bathroom, yelled at her to stop acting like that, and strangled her to the point where she couldn't breathe. She tried to push him off, went into the bedroom to get her belongings. And then at that point, she saw the defendant had her phone and was going through her phone, and she tried to get it back. He made her promise that she loved him and wouldn't call her cousin or 911. At that point, he pushed her onto the bed and went into the bathroom with her phone. She followed, trying to get her phone back because she's obviously terrified in this situation. He told her to get on her hands and knees and beg for forgiveness. When she refused and stood up and tried to leave, he strangled her again, a third time, from behind, pulling her backwards. He started dragging her from the bathroom to the bedroom and threw her onto the bed. She couldn't breathe. She blacked out. She couldn't speak. He tried to get her phone back because he still had it at this time. And at that point, he again reiterated that she needed to promise him that she loved him and that she wouldn't call him. Continued to push her down, to pin her down. And it was only after an extended period of time and she threw a water bottle at him that she was able to get her phone back and call. But it went on for an extended period, including 3 separate instances of strangulation, one causing her to feel dizzy, one to the point where she actually blacked out. This was a prolonged, continued period of violence, and we have a significant concerns for the victim's safety.
Your Honor, I agree that a lot of those facts are in the police report, but I also have to supplement. First of all, if those allegations are made, that doesn't mean they're true. They're represented as that is what happened in this case, and we have absolutely defenses to those things. I will say this because I don't think it's proper to litigate a case at a bond motion, but I can say this, that I agree that
I'll
after.
tell you what, I'm going to need a written motion. If you can get it to me today, I'll hear this afternoon, but I can't stop the docket to go through this in this entirety this morning. I will be more than happy to set you today at 3:00 to listen to this in its entirety.
Your Honor, may we approach? And I'll be happy to do what the court asks, but may we approach?
Yes.
Thanks.
A few moments later.
Okay, so what are we doing?
Thank you very much, Your Honor. I will be back this afternoon as the court.
I'll hear it at 3:00.
I just thought of something else. I'm sorry. I won't be arguing. Can I approach again real quick? I'm sorry.
Yes.
I have to ask this question.
Court does call the case, People versus Robert. Is it Droszewski?
Attorney Morgan Rourke on behalf of the people.
Written on behalf of Mr. Jaruzelski. Your name for the record.
Robichewski, Robert. Good morning, Your Honor.
Good morning.
How you doing, sir?
I'm doing well. Yourself?
Not well, sir.
This is another matter in which we do not yet have an updated report.
Do not yet have the report, you mean?
Why am I being denied an attorney? Why is an attorney coming to see me?
Like that.
Hold on.
Your Honor.
Hold on a second.
Yes, please. Yes, sir.
So
Sorry.
we're looking,
Apologies.
you're looking for a report on this case.
Yes.
And we don't have it yet. Did both cases get referred over or just one?
I see that the 1052 is competency. The 1188 appears to be a bond violation.
Got it. Okay, so because that one's set for just a straight PCC, isn't it?
That is correct, Your Honor. 1188 was just.
All right. We haven't heard anything from,
I have not.
all right, what was our dates?
I've told him that I'm willing to cooperate.
All right, so here's what I'm gonna do. September 26, 2024 at 9 a.m. I will move the date up. To keep them together, I would also set this case for PCC that date, but move it up, or what do you want me to do on that?
So he has not even yet been spoken to by CMH. So
Pardon?
he's not even had the interview yet with CMH. So I'm going to keep that in mind.
Okay.
Your Honor. Good morning,
Yes.
sir.
Yes,
I've been
sir.
just so you know, I've been requesting to speak with someone, and I've sent numerous letters. I've called the public defender's office to talk to an attorney about questions I have relating to this competency, why it was even ordered in the first place. I've requested copies of the motions as to why I was even sent a motion to have me for a competency, and no one's answering me, no one's talking to me. And personally, I don't even believe that I should be going to forensics, sir. I mean, if there's a hearing that we can have, that a lawyer can talk to me. I've been trying to talk to a lawyer for 5 months now, and I've been rejected every time. I've been laughed at in my face by other attorneys when they've seen me in the courtroom about this violation for talking to my girl on the phone. They literally laughed in my face when I asked them questions. The lawyer who asked me, who put in the motion for competency, when I asked him about evidence in the case, his exact words to me, Your Honor, were, quote, "I am not going to do anything you ask me to do," unquote. And I had some choice words for him. We came into the court. He filed a motion for competency against me. Why am I sitting here 5 months
It's
later?
not, sir. It's,
I mean, I understand, Your Honor.
I was not part of the conversation, but I would say that, first of all, a competency is not filed against you.
I understand that, sir.
Okay, so
But why am I being denied an opportunity to speak to a lawyer about the competency issue and about the motion in the first place? They're telling me that they can't even talk to me.
I don't think that they would have said that.
Your Honor,
They
I've called the
can't.
public defense,
Okay.
pardon my interruption.
Go ahead. What were you gonna say?
I'm sorry, sir.
What were you gonna say? Go ahead.
I've called the public defender's office 3 times. They've told me that no lawyer will talk to me. I've sent 4 or 5 letters to the public defender's office requesting to talk to an attorney specifically about this competency motion and examination that I had questions, and no one responds to me.
Okay, so Mr. Brown, I'm gonna set these dates. You'll make sure that
We'll
somebody
make
gets
sure
down
that-
and talks to him about this.
Absolutely.
So he has an understanding as to why it's proceeding in that way.
Absolutely. We will make
All
sure.
right.
there's communication.
So I'm setting it for the 26th. And then September 26th, 9 a.m. That date, so that you understand, sir, if we get a report, like if we talk to you, we get a report, that date gets moved up. So things will happen a lot faster once that occurs. Got
I
it?
appreciate you, Your Honor, and I'm not trying to be difficult. I've been laying up here for 5 months and I'm like,
Sir,
frustrated.
Sir, I'm not thinking that you're trying to be difficult. You had some questions. Some of them I can't answer.
Yes, sir.
Okay, so what I've asked Mr. Brown is to make sure that somebody gets down and talks to you, kind of explain this whole process.
Thank you, sir.
All right?
I was wondering if you could tell me what the status of his phone privileges are.
Alexander's all I know.
Status of his phone privileges?
His name when I got up and left. That's
I do
Alexander.
not see an order. Yes, I do. On case. Right. I don't have my date, on June 21st, 2024, his phone privileges were revoked pending a hearing.
Okay. I will reach back out to the jail and make sure that they're in that order. Because my understanding is that his calls were continuing to the victim through at least June 26th. So I'm concerned.
Well, let me put it this way. I signed the order from June 21st. I can see that it was stamped in June 24th. And I would suspect that the jail has done something only because then we're talking 2 days later.
Okay.
So.
Thank you.
Welcome. All right, bond will continue. Thank you. Court calls the case, People versus Amen. Is it Endrick? Enrenreich.
I've never got that wrong. Deputy Chief, one Brown.
Whoa.
I did nothing.
Whoa.
I did nothing.
Right here. Stay right here.
I did nothing. What did I do?
Stay right here.
I left 2 notes. One for the
No, face me. Face me.
Good
And
morning.
don't ever do that again.
I left a piece of paper.
Ever do that again.
It's a piece of paper.
If you come out, you walk to that podium. Am I understood? Am I understood?
Yes, Your Honor.
Go ahead, counsel.
One Brown, Deputy Chief Public Defender, being written on behalf of Mr. Amit Ehrenreich. Please state your name for the record.
To ensure justice is made, I will make 5 brief statements and then state my name.
No,
Dana
you will
from the
state
forensic
your
center
name. You
had
will
first
state
met me
your
on
name.
of July 20.
Take him back.
Yet.
Take him back.
7 months later.
Because take him back. He'll follow the rules or not. Have a good day. We may call you back. We may not. Okay.
So, Your Honor, for the record,
For the record, what?
Mr. Ehrenreich remains incompetent, but I guess that.
Yeah, I know. And I think he technically has to be here. I don't know that he's forfeited the right. Ms. Hughes, are you okay?
Sorry, I'm embarrassed. I'm sorry.
No, why embarrassed? What are you embarrassed about?
I'm sorry. I'm totally kind of disordered. I'm really sorry.
Okay, no, go ahead. She shouldn't be embarrassed by it. Okay, so we all have to be real. Had that been Blanche, he would have been punched. So I'm just saying. I mean, guy would have been tagged out, he'd be down.
Are we going to just pass this and have him come back later?
Oh, man. Court calls the case, People versus Tariq Day.
No, look, somebody has the people.
And I don't believe that our office is any longer connected to this number.
You don't believe that you are? Why? What? So? Well, yeah, but he's got to tell me that.
You do.
You do. Oh, yeah, you're on the case. Till I say otherwise. Not, probably not going to happen. Your name?
I'm sorry, I didn't hear you.
Your name.
Tariq Samar Tariq Ade.
Okay. All right. What are we doing on this case?
Oh, I'm still waiting for the hearing for the jurisdiction hearing. I put in the
For what?
jurisdiction hearing, put in a motion for dismissal for lack of jurisdiction.
When did you put that motion in?
It's been, I'm not sure when it was.
Did you
filed.
file a written motion?
Yes. I didn't get a receipt or anything. They said they filed it and or at some time, I never.
Have the people received a copy of a motion regarding jurisdiction?
No, in May, the last time a different prosecutor and your honor and everybody else was here, there was conversation on the record about the defendant having filed a motion. We're still waiting for the defendant.
Competency. I don't have a competency report.
There's a quote we'd like to quote, your honor, in our files. And the quote is about how we will not be addressing this until the competency report is back.
Thank you.
And then it would have to go through his counsel.
And the other thing, okay, so that you, counsel, I will give you an opportunity to look at it because I don't know what to make of it. He sent something to the court. Like an attempted to draw a check on the back of a birth certificate and then some notice of adequate assurance for performance and settlement. Whatever. So we will give counsel an opportunity to look at that. I will adjourn this matter out for competency. I was giving what date? October.
Talk to.
October 20th.
They said that the competency hearing was on the 25th. I wasn't given any other information after
Say
that.
it again.
And I tried to ask him at the last hearing, and he said it would be coming in the mail.
And October 24th, 2024, 9 a.m. If we get a report prior to then I'll move the date up.
Thank you. Your Honor. So,
Thank you. Counsel, we will let you look at that. Maybe we can, what we'll do is we'll just make copies of it.
thank you.
Send it to you.
So what has happened is.
Thank you. Court calls the case of the people versus Thomas Chang.
Your Honor, Joe Simon on behalf of Thomas Chang. State your name again, Thomas.
My name is Thomas Chang.
All right. Where are we on this?
Your Honor, first of all, appreciate you allowing us to come back on the docket. Your Honor, this morning I started by saying I didn't want to make a bond reduction motion and instead was requesting a 10% privilege. And I think that technically that probably is a reduction in a sense. But I didn't want to make a bond reduction motion because I'm just coming up to speed on the case and I didn't want to go into all the detail, et cetera. There's videos to go through, et cetera. So if the court is going to, I've already made my piece on my request for the 10%. If the court is going to deny that request, then we're just going to ask the court to set a PCC date out a little bit. I dare I say that date of the 13th would work well. But if the court would grant the request, that's
All day.
my client's parents are here and prepared to do whatever the eventuality happens.
Any additional information?
Nothing further, yeah.
All right. The court, in listening to the argument on the case and reviewing the file, because I was also trying to get as much information as I could from the original arraignment and the like, which I had not reviewed or looked at or in any way processed. But in looking at that, the court would not believe that a 10% privilege on this particular bond, given the circumstances of this case at this time, would be appropriate or find that the magistrate in any way abused their discretion in doing so. So the motion for that modification is denied.
Thank you, Your Honor. I do want to know if the court could possibly give me a copy of the pretrial release order as it stands, because I don't even have that. If I can get that.
The release.
Or that, sorry, the boss.
Yeah, it's generally it's a domestic violence conditional release.
Okay,
But that's fine. You need an actual copy of the.
if I could.
We can take care of that.
Thank you very much. And
What
then
date would you would like it set for the 13th?
I understand there's a docket going on the 13th.
Why?
I understand there's a docket going on the 13th, Your Honor.
There is.
That would be
It was
great.
supposed to be limited for me, but it's apparently not doing that now because of Simon. So I will set probable cause in this matter for August 13th, 2024, 9 a.m. or as your invite indicates.
Thank you, Your Honor.
All right, Bond will continue. Thank you.
Thank you, Your Honor.
with reference to the case of Amit Einrach.
Lauren Brown, Deputy Chief Public Defender, Defendant on behalf of Mr. Aaron Reich. Go ahead and state your name, please.
To ensure justice is made, I will make 5 brief statements and then state my name. Dana from the Forensic Center had first met me on the 17th of July, 2024, 8 days ago. Yet, several months prior, she submitted a report in my case without having known me at all. She didn't even know me. That was several months ago. I just seen it eight days ago. The total time I'd ever spent at the Forensic Center is about an hour. The court claims that I'm incompetent, yet neither the Forensic Center nor anyone else has provided me with any help. Why then is my sentencing being delayed for 6 months as of now? No attorney, such as Mr. Brown, has ever met or spoken to me about the details of my case. None. So how is he qualified to represent me, with all due respect to him? My case is full of lies and inaccuracies. Under such conditions, no judge, even the most qualified one, can reach at the truth. And the last one, someone with advanced spiritual abilities is controlling the minds of everyone I come into contact with. It is hard and almost impossible to believe, but that is the truth. With that, I'm complete, and my name is Amit Ehrenreich.
I don't really care now.
Then,
So-
can I address one thing? He said,
Yes,
we haven't talked to him. Usually when we have clients who are being referred for competency, it's a policy that we don't go and discuss the case with them until they have been shown to be competent.
But even prior to that, you've never met with me, you've never spoken to me, I've never seen you. How in the world are you qualified, with all due respect, to represent me? Had you known me, had you known the details of my case, had you listened to me, yes, you would have been a qualified lawyer, but otherwise, how can you represent me?
oh,
Even before
he's
the
very
competency
qualified. Are you done? That was a question. Are you done now?
I'm willing to listen.
Are you done? I have a report. There is no other additional evidence from either side.
None, Your Honor.
This report indicates that in the opinion of the examiner, that this individual remains incompetent to stand trial. In this matter, there being no other evidence to the contrary, defendant is at this point deemed incompetent. I'll set a review hearing for October 24, 2024, 9 a.m. Bond will continue. Thank you.
Nothing. How in the
You
world
can
does it
leave
change?
my courtroom now. Go with the deputies. Thank you.
Respect to you, man.
Yeah, go ahead. Just go with them, please. Thank you. At the end of that block. Thank goodness. Court stands in recess.
All right.